Question 1. Tanya, a small business owner, emails a proposal to a supplier. I will buy 500 units of your product at $10 each if you confirm by Friday. The supplier replies on Thursday, we accept, but delivery will be in 2 weeks instead of 1 week as you requested. Tanya does not respond. On Friday, she finds a cheaper supplier. Is there a binding contract? A, yes, because the supplier accepted within the deadline. B, no, because Tanya's proposal was an invitation to treat, not an offer. C, no, because the supplier's reply introduced new terms and constitutes a counteroffer. Yes, because the variation in delivery time is a minor term that does not affect the contract's substance. The correct answer is C. Let's see why this changes the legal position. A valid acceptance must match the offer without changing important terms. Here, the supplier did not simply accept Tanya's offer. They changed the delivery time from 1 week to 2 weeks, and delivery time is a material term in a business agreement. That change turns the reply into a counteroffer, which legally rejects the original offer. Option A is not correct because replying before Friday is not enough when the reply changes the offer. Option B is not correct because Tanya's message was clear enough to be an offer, with quantity, price, and deadline stated. Option D is not correct because delivery time can affect business planning, stock, and customer commitments, so it is not just a minor variation. The key idea is simple. Acceptance must mirror the offer, or it becomes a counteroffer. Question 2. TechCo placed an advertisement announcing a reward of $10,000 for anyone who develops a specific software module and submits it by June 1st. Maria, completely unaware of the advertisement, developed the module and submitted it on May 15th. She later saw the ad and now claims the reward. Which statement best describes the legal position? A. Maria can claim the reward because she performed the requested act. B. Maria cannot claim the reward because she was unaware of the offer at the time of performance. C. The advertisement is an invitation to treat, so no contract was formed. D. TechCo must pay a reduced reward because they benefited from her work. The correct answer is B. Let's break down the key issue here. For a unilateral offer, the person claiming the reward must know about the offer when performing the requested act. Maria completed and submitted the module before she knew the reward existed, so her performance was not acceptance of TechCo's offer. In contract law, you cannot accept an offer you do not know about. Option A is not correct because performance alone is not enough without knowledge of the offer. Option C is not correct because reward advertisements can operate as unilateral offers when they promise payment for a specific act. Option D is not correct because receiving a benefit does not automatically create a contract or a reduced reward obligation. The main point to remember is this: acceptance must be made with knowledge of the offer. Question 3. Delta Limited mailed a purchase order for 200 tons of steel to Omega Steel Company on Monday. Omega received the order on Tuesday and immediately posted an acceptance letter. On Wednesday, before the letter arrived, Delta telephoned Omega to withdraw the order. The acceptance letter was delivered on Thursday. Under the postal acceptance rule, is there a contract? A, yes, because acceptance was effective upon posting, creating a contract on Tuesday. B, no, because Delta's revocation reached Omega before the acceptance letter was received. C, yes, but only if the letter was properly addressed and stamped. D, no, because the postal rule does not apply to commercial contracts. The correct answer is A. Here is the timing point that decides everything. Under the postal acceptance rule, acceptance becomes effective when the acceptance letter is posted, not when it is received. Omega posted the acceptance on Tuesday, so the contract was formed on Tuesday. Delta's attempt to withdraw the order on Wednesday came too late because the acceptance had already taken legal effect. Option B is not correct because the revocation happened after acceptance was already complete. Option C is not the best answer because proper posting supports the rule, but the main legal effect is that acceptance occurred on Tuesday. Option D is not correct because the postal rule can apply in commercial contracts when using post is reasonable. The key idea is that posting the acceptance can lock in the contract before the letter arrives. Question 4. Evaluate each statement as true or false. For a contract to be voidable for duress, the threatened act must be unlawful. The correct answer is false. A person who signs a written contract is bound by its terms even if they did not read it, except in cases of fraud or misrepresentation. The correct answer is true. Once a contract is frustrated, all obligations are discharged and money paid before the frustrating event is always recoverable. The correct answer is false. Specific performance is an equitable remedy available as of right for breach of contract. The correct answer is false. Let's tie these rules together clearly. Duress does not always require an unlawful threat, because even pressure involving lawful action can be illegitimate if it leaves the other party with no real choice. A signed contract usually binds the signer, even when they did not read it, although fraud, misrepresentation, or a fundamentally different document can change that result. Frustration ends future obligations, but money already paid is handled through legal adjustment, so recovery is not automatic in every case. Specific performance is also not automatic because courts grant it only where damages are not enough and where fairness supports the order. The main point is that contract remedies and defenses depend on legal limits, fairness, and court discretion. Question 5. Mrs. Patel entered into a franchise agreement with a well-known fast food chain. The contract required the franchisor to provide ongoing marketing support. After 1 year, the franchisor unilaterally terminated all marketing activities, severely affecting Mrs. Patel's sales. She claims damages for breach. Which basis for measuring damages is most appropriate? A. Reliance damages, covering the initial franchise fee and setup costs. B. Restitutionary damages, forcing the franchisor to disgorge profits made from her fees. C. Expectation damages, to put her in the position she would have been in had the marketing support continued. D. Nominal damages, as the breach did not cause physical loss. The correct answer is C. Let's focus on what contract damages are trying to restore. Expectation damages aim to put Mrs. Patel in the financial position she would have occupied if the franchisor had kept providing marketing support. Since the missing marketing reduced her sales, the proper measure is the profit she likely lost because the contract was not performed as promised. Option A is not the best answer because reliance damages look backward at wasted spending, while this claim is mainly about lost benefit from performance. Option B is not correct because restitution focuses on stripping gains, not compensating her lost sales. Option D is not correct because financial loss from reduced sales is real contractual loss, even without physical damage. The key point is simple. Expectation damages protect the benefit of the bargain. Question 6. An auditor, Green & Company, negligently certified the accounts of XYZ Limited, knowing the accounts would be shown to a potential investor, Beta Incorporated. Relying on the audit report, Beta invested and later suffered substantial financial loss when inaccuracies emerged. Beta now sues Green & Company for negligent misstatement. What test will a court primarily apply to determine whether a duty of care was owed to Beta? A. The but-for test of causation. B. The 3-stage test of foreseeability, proximity, and whether it is fair, just, and reasonable to impose a duty. C. The neighbor principle from Donahue versus Stevenson. D. The assumption of responsibility test, considered in isolation. The correct answer is B. Let's focus on the duty of care issue. In negligent misstatement involving financial loss, the court looks beyond simple carelessness and asks whether a duty of care should legally exist. The key test considers whether the loss was foreseeable, whether there was sufficient proximity between the auditor and the investor, and whether imposing a duty would be fair, just, and reasonable. Here, Green & Company knew the accounts would be shown to a potential investor, so proximity and foreseeability become central. Option A is not correct because the but-for test deals with causation, not whether a duty exists. Option C is too broad because the neighbor principle is a foundation of negligence, but this situation needs a more specific duty analysis. Option D is not correct because assumption of responsibility may be relevant, but it is not applied alone as the complete test here. The key lesson is that financial loss claims need a careful duty test, not just proof that the statement was careless. Question 7. XYZ Enterprises agreed to supply information technology equipment to a retail chain. A clause in the contract limited XYZ Enterprises' liability for late delivery to $5,000. The delivery was 6 months late, causing the retail chain $100,000 in lost profits. The retail chain argues the limitation clause is unconscionable. Which doctrine would a court most likely use to review the clause? A, the doctrine of frustration. B, the doctrine of privity of contract. C, the requirement of good faith in performance. D, the test of whether the clause is fair and reasonable under applicable unfair contract terms legislation. The correct answer is D. Let's look at the control mechanism the court would use. A limitation clause can restrict liability, but it may still be reviewed where legislation allows the court to test whether the term is fair and reasonable. Here, the clause limits liability to $5,000, despite a much larger loss. So the key question is whether that limit is legally acceptable in the circumstances. Option A is not correct because frustration deals with events that make performance radically different, not liability caps. Option B is not correct because privity concerns who can enforce a contract, not whether a clause is fair. Option C is not the strongest answer because good faith may affect performance, but unfair contract terms legislation is the main tool for reviewing this type of clause. The main idea is that limitation clauses can work, but they must survive the fairness and reasonableness test. Question 8. An art dealer, Leo, told a buyer, "This painting is an original Picasso." The buyer, relying on this statement, purchased the painting for $200,000. It was later discovered to be a clever forgery worth only $2,000. Leo honestly believed it was genuine after a superficial inspection, but had no reasonable grounds for his belief. Under tort law, what type of claim is most appropriate against Leo? A, fraudulent misrepresentation. B, innocent misrepresentation. C, breach of a contractual warranty. D, negligent misstatement under the principle in Hedley-Byrne because a special relationship existed. The correct answer is D. Here, the key issue is the quality of Leo's statement. Leo was an art dealer, so the buyer could reasonably rely on his expertise when he stated that the painting was an original Picasso. Because Leo honestly believed the statement, this is not fraud. However, his inspection was only superficial, and he had no reasonable grounds for making such a serious claim. So the statement becomes negligent. Option A is not correct because fraud requires dishonesty or reckless disregard for the truth. Option B is not correct because Leo's belief lacked reasonable grounds, so it is not truly innocent. Option C is not the best answer because the question is asking under tort law, not a contractual warranty claim. The point to remember is simple. An honest statement can still create liability if it is made carelessly by someone others rely on. Question 9. A partnership of 3 architects is dissolved after one partner retires. Before retirement, the firm signed a contract to design an office building. The remaining 2 partners completed the project but incurred a loss. The retired partner now claims a share of the profits from the completion. Which statement correctly states the position? A, the retired partner is fully liable for the loss and entitled to a share of the profits as a dormant partner. B, the retired partner remains liable for pre-dissolution obligations and is entitled to a share of profits earned from work in progress, subject to the partnership agreement. C, the retired partner is not liable for any post-dissolution obligations and cannot share in profits. D, the retired partner is automatically discharged from liability if the remaining partners novate the contract. The correct answer is B. Let's settle this through the timing of the obligation. The office building contract was signed before the partner retired, so it is a pre-dissolution obligation. Retirement does not automatically erase liability for obligations already incurred by the partnership. At the same time, where unfinished partnership work is completed after retirement, the outgoing partner may have a claim to a share connected to that work, depending on the partnership agreement and the final accounting. Option A is not correct because the retired partner is not simply treated as a dormant partner after retirement. Option C goes too far because pre-dissolution obligations can still affect the retired partner. Option D is not correct because novation requires proper agreement and does not automatically discharge the retired partner by itself. The key idea is that retirement ends future participation, but it does not wipe out unfinished partnership business. Question 10. Mr. Tan, a director of Omega Private Limited, signed a contract to purchase office equipment for $80,000 on behalf of the company. The company's constitution required board approval for all purchases exceeding $50,000. The supplier had no notice of this restriction. Omega now refuses to pay. Can the supplier enforce the contract? A. No, because the director acted without authority. B. No, because the supplier should have examined the publicly filed constitution. C. Yes, under the indoor management rule, the supplier was entitled to assume that internal procedures had been complied with. D. Yes, but only if the director had express authority. The correct answer is C. Let's focus on the supplier's position outside the company. The indoor management rule protects outsiders who deal with a company in good faith. The supplier was entitled to assume that Omega's internal approval process had been properly followed, especially because there was no notice of the missing board approval. So Omega cannot avoid payment simply by pointing to an internal procedural failure. Option A is not correct, because lack of internal approval does not automatically defeat the rights of an innocent outsider. Option B is not correct, because outsiders are not usually required to investigate every internal approval step before contracting. Option D is not correct, because the rule can protect the supplier, even where the authority depends on internal compliance, not only express authority. The key takeaway is that outsiders can usually trust that a company has handled its own internal formalities. Question 11. Evaluate each statement as true or false. A minor, a person under the age of majority, can always repudiate a contract for non-necessary goods without any liability. The correct answer is false. An agency relationship can be created retrospectively by ratification, even if the agent had no authority at the time of the act. The correct answer is true. In a sale of goods, the rule nemo dat quod non habet means that a buyer can obtain better title than the seller had if the buyer acted in good faith. The correct answer is false. A traditional partnership does not have separate legal personality from its partners. The correct answer is true. Let's make the rules easy to separate. A minor is protected in many contracts, but that protection is not absolute, because liability may still arise for necessaries, beneficial service contracts, or goods that must be returned while still in the minor's possession. Ratification can approve an unauthorized act later, so the agency relationship can take effect retrospectively, as long as the principal existed and had capacity at the relevant time. The nemo dat rule means a seller transfer a better title than they own, so good faith alone does not automatically cure a defective title. A traditional partnership is generally treated as the partners acting together, not as a separate legal person like a limited liability entity. Remember this: capacity, authority, title, and legal personality each have their own limits. Question 12. A software development firm contracted with a client to deliver a custom inventory system by June 1. Unforeseen but not extraordinary technical difficulties delayed delivery until August 1. The client lost a major contract because of the delay and now sues for consequential losses. The contract excluded liability for any indirect or consequential loss. What is the likely effect of the exclusion clause? A. The clause will be interpreted to exclude liability for losses such as lost profits from the delayed system, but direct losses may still be recoverable. B. The exclusion clause is void because delay is a fundamental breach. C. The clause is ineffective because it was not individually negotiated. D. The clause is valid and completely exempts the firm from all damages, including direct damages for breach. The correct answer is A. Let's focus on what the exclusion clause actually removes. An exclusion of indirect or consequential loss usually targets special losses that do not arise in the ordinary course unless the breaching party knew about special circumstances. Here, the lost major contract is the kind of consequential loss the clause is likely to exclude. However, that does not mean the software firm escapes all liability, because direct losses from the delay may still be recoverable. Option B is not correct because a serious breach does not automatically make an exclusion clause void. Option C is not correct because a clause is not automatically ineffective simply because it was not individually negotiated. Option D is not correct because the wording only excludes indirect or consequential loss, not every possible type of damage. The key point is that exclusion clauses are read according to their wording, so consequential loss can be excluded while direct loss remains available. Question 13. An agent, Mr. Green, contracted to buy timber in his own name without disclosing the existence of his principal, Woodworks Limited. The timber supplier, believing Green to be the principal, now discovers Woodworks Limited and wishes to pursue a claim. What is the supplier's position? A. The supplier can sue only Green because the principal was undisclosed at the time of contract. B. Woodworks Limited cannot be liable because an agent cannot bind an undisclosed principal. C. The contract is void for mutual mistake. D. The supplier may elect to sue either Green or Woodworks Limited, as the undisclosed principal can be held liable. The correct answer is D. Let's look at who the supplier can hold responsible. When an agent contracts in their own name for an undisclosed principal, the contract can still bind the principal once that principal is discovered. The supplier is not trapped into suing only Mr. Green. Instead, the supplier may choose whether to pursue Mr. Green, who appeared to be the contracting party, or Woodworks Limited, the real principal behind the transaction. Option A is not correct because the supplier is not limited to the agent once the principal is revealed. Option B is not correct because an undisclosed principal can be bound by the agent's authorized act. Option C is not correct because the contract is not void merely because the supplier did not know the principal existed. The key idea is that an undisclosed principal can step into liability once discovered. Question 14. The rule that consideration must be sufficient but need not be adequate means A. The court will evaluate whether the exchanged values are roughly equal. If not, the contract fails. B. Consideration must have some value in the eyes of the law, but the court will not assess its economic fairness. C. A promise to perform an existing public duty is always sufficient consideration. D. Moral obligation alone can constitute consideration. The correct answer is B. Let's pin down the legal meaning of value here. Consideration must be real enough for the law to recognize it, but it does not have to be equal or commercially fair. So even something small, like a token payment, can support a contract if it has legal value. The court is not there to rewrite the bargain just because one side made a better deal. Option A is not correct because courts do not usually compare whether the exchange is economically balanced. Option C is not correct because performing an existing public duty is generally not fresh consideration unless something extra is provided. Option D is not correct because moral obligation alone is not legal consideration. The key idea is simple. The law checks for legal value, not fairness of the price. Question 15. A manufacturer of electric kettles discovers a production defect that may cause overheating. Jody buys one of these kettles. The kettle overheats, causing a small fire that damages her kitchen. Jody sues the manufacturer in tort. Under modern product liability law, which cause of action is most appropriate? A. Breach of contract, because there is an implied warranty of merchantability. B. The tort of deceit, as the manufacturer knowingly sold a defective product. C. The tort of negligence, based on failure to test the kettle properly. D. Strict product liability for damage caused by a defective product. The correct answer is D. Let's go straight to the nature of the claim. Modern product liability often makes producers strictly liable when a defective product causes harm, but especially where the defect leads to property damage or personal injury. Jody does not need to prove a careless testing process if the legal regime imposes liability because the product itself was defective and caused the kitchen damage. Option A is not correct because the question asks for a tort-based product liability claim, not a contract claim against the seller. Option B is not correct because deceit requires proof of dishonest misrepresentation, not just a defective product. Option C may sound possible, but negligence is not the strongest answer, where strict product liability directly covers damage caused by a defective product. The key point is that strict product liability focuses on the defect and the damage, not on proving fault. Question 16. A and B are negotiating a joint venture. A emails B a draft agreement. B responds, "I accept your terms in principle, but my board must approve." Before board approval is obtained, A informs B that the deal is off. B later obtains board approval and declares a binding contract. Is there a contract? A, yes, because B's acceptance was unconditional and internal approval is a mere formality. B, no, because B's response was a counteroffer. C, no, because B's statement was a conditional acceptance that does not create a contract until the condition is fulfilled. D, yes, because the postal rule applies to electronic communications. The correct answer is C. Here, the words after in principle are doing the real work. B did not give a final and unconditional acceptance because the response depended on board approval first. Until that approval happened, there was no complete acceptance and no binding contract. Since A withdrew before the condition was satisfied, B could not later create a contract just by getting approval afterward. Option A is not correct because board approval was made a condition, not a mere background formality. Option B is not the strongest answer because B was not proposing different terms, but making acceptance conditional. Option D is not correct because the postal rule does not control this email situation, and in any case, there was no unconditional acceptance to begin with. The key point is that subject to approval usually means no binding contract until approval is actually given. Question 17. The term quantum meruit in contractual remedies refers to A claim for specific performance of a contractual obligation. B, a restitutionary claim to recover a reasonable sum for services rendered when a contract is partly performed and then terminated. C, an action for damages arising from fraudulent misrepresentation. D, a statutory penalty payable by a party who breaches a contract. The correct answer is B. Let's keep the remedy clear and practical. Quantum meruit means claiming a reasonable payment for work or services already provided. It is often used where a contract has been partly performed, then ended, and one party would otherwise receive the benefit without paying fairly for it. The focus is not on enforcing the whole contract, but on preventing unjust enrichment. Option A is not correct because specific performance forces a party to carry out the contract. Option C is not correct because fraudulent misrepresentation concerns deceit and loss caused by dishonesty. Option D is not correct because quantum meruit is not a penalty for breach. The key idea is simple. Quantum meruit means reasonable payment for value already given. Question 18. Evaluate each statement as true or false. In contract law, an invitation to treat is an offer capable of acceptance. The correct answer is false. An exclusion clause that seeks to exclude liability for death or personal injury resulting from negligence is generally void under most modern commercial statutes. The correct answer is true. The doctrine of promissory estoppel can be used as a cause of action to enforce a promise without consideration. The correct answer is false. A contract formed under a mutual mistake as to the existence of the subject matter is void ab initio. The correct answer is true. Let's separate these rules cleanly. An invitation to treat only invites another party to make an offer, so it cannot be accepted as a final offer by itself. An exclusion clause for death or personal injury caused by negligence is generally ineffective because modern statutes usually prevent businesses from contracting out of that level of responsibility. Promissory estoppel normally protects a party from strict legal enforcement of rights, but it does not usually create a fresh claim where consideration is missing. A mutual mistake about the existence of the subject matter means the contract fails from the beginning because there was nothing real for the agreement to attach to. The key idea is this. Contract law separates negotiation, enforceable promises, statutory limits, and mistakes very carefully. Question 19. Company X entered into a long-term supply contract with Company Y. A subsequent government ban on importing the essential raw material frustrated the contract. Before the ban, Y had paid X a $50,000 advance. How is the advance likely to be treated under frustration? A. X must return the entire $50,000 because the contract is void. B. X may retain a portion of the advance to cover expenses reasonably incurred before the frustrating event, as permitted by statute. C. Y cannot recover any part of the advance because frustration only discharges future obligations. D. The advance is automatically forfeited to the state. The correct answer is B. Let's focus on what happens to money already paid. When a contract is frustrated, future obligations usually end, But money paid before the frustrating event is not handled by a simple all-or-nothing rule. Modern frustration legislation may allow the court to order repayment while also letting the receiving party keep a fair amount for expenses reasonably incurred before the event occurred. That balances the loss between both sides instead of giving one party an unfair advantage. Option A is not correct because the full advance is not always automatically returned. Option C is not correct because frustration can affect prepaid money through statutory adjustment. Option D is not correct because there is no rule that forfeits the advance to the state. The key point is that frustration ends the contract, but the court can still make a fair financial adjustment. Question 20. David sold a car to Maria, stating it was a 2019 model with only 20,000 kilometers on the odometer. In truth, it was a 2017 model with 60,000 kilometers, and David knew this. Maria later discovers the truth and wishes to rescind the contract and claim damages. What type of misrepresentation has David made? A. Innocent misrepresentation. B. Negligent misrepresentation. C. Fraudulent misrepresentation. D. Unilateral mistake. The correct answer is C. Let's look at David's state of mind. Fraudulent misrepresentation happens when a person knowingly makes a false statement or makes it recklessly without caring whether it is true. David knew the car was not a 2019 model and knew the mileage was not 20,000 kilometers, yet he stated both facts as true. That makes the misrepresentation dishonest. So Maria may seek rescission and damages for deceit. Option A is not correct because the statement was not made honestly. Option B is not correct because this is more than carelessness. David actually knew the truth. Option D is not correct because the issue is not a mistake by one party, but a deliberate false statement that induced the contract. The key idea is simple. A false statement made knowingly is fraud. Question 21. Dr. Lane, a director of a pharmaceutical company, learns from confidential company research that a new drug will fail clinical trials. Before the information is made public, she sells all her shares in the company. Is she in breach of any duty? A. No, because directors are free to sell their shares at any time. B. Yes, she breached her duty of care to the company. C. Yes, she breached her fiduciary duty by making personal profit from confidential corporate information, insider trading prohibition. D. No, because the shares were her personal property and no company funds were used. The correct answer is C. Let's focus on how she used the information. Dr. Lane was not just selling shares casually. She used confidential, price-sensitive company information before the market knew about it. As a director, she owes fiduciary duties and must not use corporate information for personal advantage or to avoid personal loss. That conduct also falls within insider trading concerns because she acted before the information became public. Option A is not correct because directors cannot freely trade when they hold confidential market-sensitive information. Option B is too narrow because the issue is not careless management, but misuse of confidential information. Option D is not correct because personal ownership of the shares does not allow improper use of corporate information. The key point is simple. Directors must not trade on confidential company information. Question 22. ABC Limited's Articles of Association require all contracts over $100,000 to be approved by the board. The chief executive officer, without board approval, signed a $150,000 contract with a supplier who had no knowledge of the restriction. The supplier now demands performance. Is the company bound? A. No, because the chief executive officer acted beyond his express authority and the contract is void. B. Yes, under the indoor management rule, the supplier could assume internal procedures had been followed. C. No, because the supplier is deemed to have constructive notice of the articles. D. Yes, but only if the chief executive officer had implied actual authority. The correct answer is B. Let's focus on the protection given to outsiders. The indoor management rule protects a third party who deals with a company in good faith and has no notice of an internal defect. Since the supplier did not know that board approval was missing, the supplier could assume the company had properly followed its internal approval process. That means ABC Limited is likely bound by the contract. Option A is not correct because an internal authority problem does not automatically make the contract void against an innocent outsider. Option C is not correct because the indoor management rule softens the harshness of constructive notice in this type of situation. Option D is not correct because the supplier's protection does not depend only on proving implied actual authority. The key point is that outsiders are generally allowed to trust that a company has handled its own internal approvals. Question 23. The rule on remoteness of damage in contract law provides that A, the defendant is liable for all losses that flow directly from the breach, regardless of foreseeability. B, the defendant is liable only for losses that were in the reasonable contemplation of the parties at the time of contracting as the probable result of breach. C, the test is identical to the tort test of direct consequence. D, remoteness is irrelevant. Once breach is proved, all consequences must be compensated. The correct answer is B. Let's lock in the Hadley versus Baxendale rule. Contract damages are limited to losses the parties could reasonably contemplate when they made the contract. That means the loss must either arise naturally from the breach or be a probable result known to both sides at the time of contracting. This prevents liability from stretching to every unexpected consequence after a breach. Option A is not correct because foreseeability still matters. Option C is not correct because contract remoteness is not identical to the tort test. Option D is not correct because remoteness is very important. Breach does not open the door to every possible loss. The key point is simple. Contract damages must be reasonably foreseeable when the contract is made. Question 24. A famous chef, Pierre, endorses a brand of cookware in a television advertisement, stating, "This pan's non-stick surface will never scratch or peel, guaranteed for life." Relying on this statement, a consumer buys the pan. After 2 months, the coating peels off. Under what basis can the consumer likely sue Pierre directly? A, breach of contract because the advertisement was an offer to the public. B, the tort of negligent misstatement as Pierre carelessly made an unverified statement. C, product liability because Pierre is the manufacturer. D, breach of collateral warranty as the statement was intended to induce the contract and was relied upon. The correct answer is D. Let's focus on the promise Pierre made to drive the sale. A collateral warranty can arise when a strong statement is made to persuade someone to enter a contract, and the buyer relies on it when purchasing. Pierre's guarantee was more than casual advertising praise because it promised the pan would never scratch or peel. Since that promise induced the purchase, the consumer may sue Pierre directly on the collateral warranty. Option A is not correct because the advertisement is not usually the main sale contract with Pierre. Option B may sound possible, but the stronger basis is the binding promise created by the guarantee. Option C is not correct because Pierre is the endorser, not the manufacturer. The key idea is simple. A serious promise used to induce a purchase can become a collateral warranty. Question 25. Evaluate each statement as true or false. Under the general law of agency, an agent who acts without authority is always personally liable on the contract. The correct answer is false. A limited liability company is a separate legal person distinct from its shareholders. The correct answer is true. Silence can never amount to a misrepresentation. The correct answer is false. In a contract for the sale of goods by sample, there is an implied condition that the bulk will correspond with the sample in quality. The correct answer is true. Let's sort out the legal limits in each statement. An unauthorized agent may be liable for breach of warranty of authority, but that does not automatically make the agent personally liable on the contract itself. A limited liability company has its own legal personality, so it is separate from the people who own its shares. Silence is usually not misrepresentation, but it can become one where there is a duty to disclose or where silence makes an earlier statement misleading. In a sale by sample, the buyer is protected because the goods delivered must match the sample in quality. The main idea is that legal responsibility depends on the role, the relationship, and the type of transaction involved. Question 26. A law firm, Smith & Partners, hires an associate and titles them partner on the firm's letterhead, Though they are a salaried employee with no share in profits and restricted authority, a client relying on the letterhead lends money to this associate in the firm's name for a personal investment. The associate misapplies the funds, the client sues the firm. What principle is most relevant? A. The firm is estopped from denying the associate's authority because it held them out as a partner and the client relied on that representation. B. The firm is vicariously liable for the fraud of an employee. C. The firm is not liable because borrowing is outside the ordinary business of a law firm. D. The associate had implied actual authority to borrow. The correct answer is A. Let's focus on what the firm represented to the outside world. By putting the associate forward as a partner on its letterhead, the firm created the appearance that the associate had partner status and authority. If the client reasonably relied on that representation, the firm may be prevented from denying it later. This is liability by holding out or estoppel because the third party acted on the firm's own representation. Option B is not the strongest answer because the core issue is apparent partnership status, not ordinary employee liability. Option C may raise a limit on authority, but it does not defeat the main principle, where the firm's representation caused reliance. Option D is not correct because the associate had restricted authority, so the issue is apparent authority rather than implied actual authority. The key point is that a firm can be bound by the authority it appears to give, especially when others rely on that appearance. Question 27. The last shot doctrine in the Battle of the Forms refers to A. The rule that the first offerer always has the right to accept the final counteroffer. B. A statutory rule giving priority to the seller's standard terms. C. The principle that a contract is formed on the terms of the party who sends the final counteroffer that is then accepted by performance without further objection. D. The requirement that acceptance must be communicated exactly in the manner prescribed by the offerer. The correct answer is C. Let's make the Battle of Forms simple. When both parties exchange different standard terms, each new set of terms can operate like a counteroffer. The last shot rule means the terms sent last before performance will usually control if the other party goes ahead without objecting. Performance then shows acceptance of those final terms. Option A is not correct because the rule is not about giving the first offeror special power. Option B is not correct because this is not a statutory preference for the seller's terms. Option D is not correct because it deals with the method of acceptance, not conflicting standard terms. The key idea is that in a battle of forms, the final unanswered set of terms often wins. Question 28. An electronics retailer displays a television in its shop window with a price tag of $500. A customer enters, points to the television, and says, "I accept your offer. Here is $500. The retailer refuses to sell, explaining the correct price is $5,000. Is the retailer bound to sell at $500? A. Yes, because the display with a price was an offer that the customer accepted. B. No, under the bait and switch law. C. Yes, because the customer's conduct was a valid acceptance. D. No, because the display of goods with a price is generally an invitation to treat, not an offer. The correct answer is D. Let's focus on who actually makes the offer. Goods displayed in a shop window are usually an invitation to treat, meaning the shop is inviting customers to make offers to buy. The customer's statement and payment attempt are therefore the offer, and the retailer can choose whether to accept or reject it. Since the retailer rejected the offer, no binding sale was formed at $500. Option A is not correct because the price display was not usually a legal offer capable of immediate acceptance. Option B is not the best answer because the issue is basic offer and acceptance, not a bait and switch rule. Option C is not correct because the customer could not accept something that was only an invitation to treat. The key idea is simple. A shop display invites offers. It does not usually bind the shop to sell. Question 29. X contracts with Y to deliver 100 barrels of oil by April 1st, and the contract expressly states time is of the essence. X delivers on April 3rd. Y refuses the goods and terminates the contract. Can Y lawfully terminate? A, no, because the delay was only 2 days and termination is disproportionate. B, yes, because time was of the essence, making the delivery date a condition, and any breach, however slight, entitles termination. C, yes, but only if Y can prove that the delay caused serious commercial inconvenience. D, no, because X substantially performed. The correct answer is B. Let's focus on the effect of that timing clause. When a contract says time is of the essence, the deadline becomes a condition of the agreement. That means performance must happen on the agreed date, not shortly after it. Since X delivered 2 days late, Y was entitled to treat the breach as serious enough to terminate, even if the delay seemed small. Option A is not correct because the clause already makes punctual delivery essential. Option C is not correct because Y does not need to prove serious commercial inconvenience once the condition is breached. Option D is not correct because substantial performance cannot cure failure to meet an essential time condition. The key point is that when time is essential, even a short delay can justify termination. Question 30. Evaluate each statement as true or false. In a bilateral contract, acceptance must be communicated to the offerer, except where the postal rule applies. The correct answer is true. A contract that is illegal at formation is voidable at the option of the innocent party. The correct answer is false. A company director's fiduciary duty to act in the company's best interests is owed exclusively to the shareholders. The correct answer is false. In a contract for the sale of goods, risk prima facie passes with property. The correct answer is true. Let's bring these rules into focus. In a bilateral contract, both sides exchange promises, so acceptance normally has to be communicated before a contract is formed, although the postal rule can make posted acceptance effective earlier. An illegal contract is generally void and unenforceable from the start, not merely voidable by one party. A director's fiduciary duties are owed to the company as a separate legal person, not only to the shareholders individually. In sale of goods, risk usually follows ownership, so once property in the goods passes, the buyer generally bears the risk unless the contract says otherwise. The key idea is that contract formation, illegality, company duties, and sale of goods each turn on precise legal rules. Question 31. A startup, Technova, entered a lease for office space. The chief executive officer, who had actual authority, signed the lease. 6 months later, the board discovers the lease is highly disadvantageous and seeks to avoid it, arguing the chief executive officer breached his duty of care. Can Technova escape the lease with the landlord? A. Yes, because the chief executive officer lacked capacity. B. No, because the lease is void ab initio. C. Yes, as long as the board can prove the chief executive officer was negligent. D. No, because the chief executive officer had actual authority and the landlord is protected by the indoor management rule. The correct answer is D. Let's separate the internal issue from the external contract. The chief executive officer had actual authority to sign the lease, so the company is bound to the landlord. Even if the board later thinks the deal was poor, that does not automatically let Technova avoid the contract with an outside party who dealt with the company in good faith. Any complaint about the chief executive officer's duty of care is mainly an internal company matter. Option A is not correct because the chief executive officer had authority and capacity was not the issue. Option B is not correct because the lease was not void from the beginning. Option C is not correct because proving negligence by the chief executive officer does not automatically cancel a valid contract with the landlord. The key point is simple. Internal mismanagement does not usually defeat a contract made with proper authority. Question 32. Which form of intellectual property right is primarily concerned with protecting the unique visual appearance or ornamentation of a product? A. Patent. B. Copyright. C. Industrial design right. D. Trade secret. The correct answer is C. Let's keep the categories distinct. An industrial design right protects the visual features of a product, such as its shape, pattern, configuration, or ornamentation. It focuses on appearance, not how the product works. So if a company wants to protect the distinctive look of a chair, bottle, phone case, or watch face, this is the relevant right. Option A is not correct because patents protect inventions and technical functions. Option B is not correct because copyright protects original creative works, not usually the industrial appearance of mass-produced products in this sense. Option D is not correct because trade secrets protect confidential business information, not visible product design. The key idea is simple. Industrial design protects how a product looks, not how it works. Question 33. Birch Limited hired a contractor to paint its factory roof. The contract required the use of scaffolding. The contractor ignored this and used a ladder, fell, and injured a passerby. The passerby sues Birch Limited for negligence. Which principle might impose liability on Birch despite the contractor's status as an independent contractor? A. Birch owes a non-delegable duty of care to ensure that work on its premises is carried out safely, rendering it liable for the contractor's negligence. B. The contractor was an employee because Birch specified the method of work. C. The rule in Rylance v. Fletcher imposes strict liability. D. Vicarious liability always applies to independent contractors. The correct answer is A. Let's focus on the duty Birch could not simply hand over. Normally, a person is not automatically liable for the negligence of an independent contractor. However, where dangerous work is being done on premises, the occupier may have a non-delegable duty to make sure reasonable care is taken. Birch required scaffolding because roof work created an obvious safety risk. So, delegating the job did not necessarily remove Birch's responsibility to those who could be harmed. Option B is not correct because setting safety requirements does not automatically make the contractor an employee. Option C is not correct because this is not about escape of a dangerous thing from land. Option D is not correct because vicarious liability does not always apply to independent contractors. The key idea is that some safety duties remain with the occupier even when the work is outsourced. Question 34. Two businesses sign a detailed written agreement containing an entire agreement clause that states the document constitutes the whole contract. During negotiations, the seller made an oral statement about the product's performance that later proved false. The buyer now wishes to claim misrepresentation. What is the likely effect of the entire agreement clause? A. The clause prevents any claim based on pre-contractual statements, even for fraud. B. The clause is irrelevant because oral statements always override written terms. C. The buyer may only sue for breach of contract, not misrepresentation. D. The clause may exclude liability for innocent or negligent misrepresentation if it is clearly worded and reasonable, but typically cannot exclude liability for fraud. The correct answer is D. Let's look at what this clause can and cannot shut out. An entire agreement clause can help limit claims based on statements made before the written contract, especially where the alleged misrepresentation is innocent or negligent. However, the clause must be clearly drafted and pass any required reasonableness test. It cannot usually protect a party from fraud because the law does not allow someone to contract out of dishonest misrepresentation so easily. Option A is not correct because fraud is treated differently and is not normally excluded by a general entire agreement clause. Option B is not correct because written terms do not automatically get displaced by earlier oral statements. Option C is not correct because misrepresentation may still be available depending on the wording, the type of statement, and the legal limits on exclusion. The key point is that an entire agreement clause may narrow misrepresentation claims, but it does not give a free pass for fraud. Question 35. A store manager, Ali, finds a lost watch and places an advertisement offering a $200 reward for its return. Bella, a regular customer who never saw the notice, finds an identical watch in the store's changing room and returns it to the service desk. Later, she learns of the reward and demands payment. Is Ali obligated to pay? A. Yes, because the offer was made to the public and Bella performed the act. B. Yes, but only half the amount because Bella did not know of the reward. C. No, because the advertisement was an invitation to treat. D. No, because Bella was unaware of the reward offer when she performed the act, so she could not accept it. The correct answer is D. Let's focus on acceptance in a reward situation. A reward advertisement can operate as a unilateral offer, but the person claiming the reward must know about it when performing the requested act. Bella returned the watch before she knew the reward existed, so her act was not acceptance of Allie's offer. She may have done the right thing, but contract law still requires knowledge of the offer before performance can count as acceptance. Option A is not correct because performance alone is not enough without awareness of the reward. Option B is not correct because the law does not create a half reward for unknown offers. Option C is not correct because reward advertisements can be treated as offers when they promise payment for a specific act. The key point is simple. You cannot accept an offer you do not know about. Question 36. Evaluate each statement as true or false. A check is a bill of exchange drawn on a banker and payable on demand. The correct answer is true. A holder in due course of a negotiable instrument takes it free from defects in title of prior parties. The correct answer is true. An agent can never delegate authority to a sub-agent without the express consent of the principal. The correct answer is false. A company's articles of association set out its external objects and powers. The correct answer is false. Let's pull these commercial law rules together. A check is treated as a bill of exchange because it is drawn on a banker and must be payable on demand. A holder in due course gets strong protection, meaning they generally take the instrument free from earlier defects in title or personal disputes between previous parties. An agent usually should not delegate authority, but delegation can be allowed where the principal consents, where trade custom permits it, or where the task is merely administrative. A company's articles mainly govern internal management, while external objects and powers are usually dealt with in the memorandum or equivalent constitutional document. The key idea is that negotiable instruments protect good faith holders, while agency and company rules depend on authority and constitutional structure. Question 37. An investor purchased shares in a company based on a prospectus that contained a negligently prepared statement about the company's patent portfolio. When the truth emerged, the shares dropped sharply in value. The investor seeks to recover the loss from the directors who signed the prospectus. Which tort action is most appropriate? A. Breach of fiduciary duty. B. The tort of deceit. C. The tort of negligent misstatement causing pure economic loss. D. Statutory action for defective prospectus, which requires no proof of fault. The correct answer is C. Let's focus on the kind of wrong committed here. The statement in the prospectus was prepared carelessly, and the investor relied on it when buying shares. That points to negligent misstatement because the loss is financial, not physical damage. If the directors owed a duty of care and the investor's reliance was reasonable, they may be liable for the pure economic loss caused by the inaccurate statement. Option A is not correct because directors' fiduciary duties are generally owed to the company, not directly to every investor in this situation. Option B is not correct because deceit requires dishonesty, and the facts point to negligence instead. Option D is not the best answer because the question asks for the most appropriate tort action, while a statutory prospectus claim is a separate route. The key point is that careless financial statements relied on by investors can support a negligent misstatement claim. Question 38. Two corporations, F and G, signed a detailed heads of agreement document that stated, "This document is not a binding contract. It is an agreement to negotiate in good faith toward a definitive agreement." F later withdrew from negotiations to pursue a more lucrative deal. G sues for breach. What is the likely outcome? A. The agreement to negotiate in good faith is unenforceable because it is too uncertain to constitute a binding contract. B. The document constitutes a binding preliminary contract, and F is liable for failing to negotiate. C. F must pay damages for fraudulent misrepresentation. D. The heads of agreement is an enforceable option contract. The correct answer is A. Let's focus on certainty and intention to be bound. A contract must be certain enough for the court to enforce. Here, the document says it is not a binding contract and only reflects an agreement to keep negotiating. That is usually too uncertain because the court cannot easily decide what final terms the parties should have reached or how long they had to keep negotiating. Option B is not correct because the wording shows the parties did not intend the heads of agreement to be immediately binding. Option C is not correct because there is no clear dishonest false statement in the facts. Option D is not correct because an option contract gives a definite right to enter a contract on fixed terms, and this document does not do that. The key idea is simple. An agreement to negotiate is usually not the same as an enforceable contract. Question 39. Piercing the corporate veil refers to A. The process by which a company issues its shares to the public. B. The exceptional circumstance where a court disregards the separate legal personality of a company and imposes liability on its shareholders or directors. C. A court order to wind up an insolvent company. D. The automatic transfer of assets to shareholders upon dissolution. The correct answer is B. Let's make the company law concept clear. A company normally has a separate legal personality, meaning it is treated as legally distinct from its shareholders and directors. Piercing the corporate veil is an exceptional step where the court looks past that separate personality and may hold the individuals behind the company responsible. This usually happens where the company's structure is being abused, such as being used as a facade to avoid legal obligations. Option A is not correct because issuing shares is a capital raising process, not veil piercing. Option C is not correct because winding up ends or liquidates a company, while veil piercing deals with personal responsibility behind the company. Option D is not correct because company assets do not automatically transfer to shareholders on dissolution. The key point is that veil piercing is rare and only used when the company form is being misused. Question 40. Evaluate each statement as true or false. A contract for the sale of goods by description contains an implied condition that the goods will correspond with that description. The correct answer is true. A principal is always liable for torts committed by an independent contractor. The correct answer is false. A gratuitous promise made under seal by deed is enforceable without consideration. The correct answer is true. The equitable remedy of rescission is available for any breach of contract. The correct answer is false. Let's bring the principles into a clear sequence. In a sale by description, the goods must match the description used in the contract because that description forms an implied condition of the sale. A principal is not automatically liable for an independent contractor's torts, although liability may still arise where a non-delegable duty exists. A promise made by deed can be binding even without consideration because the formal legal instrument replaces the need for a bargain exchange. Rescission is not a general remedy for every breach. It is mainly used where the contract was affected by matters like misrepresentation, duress, undue influence, or similar vitiating factors. The key idea is that some duties arise by implication. Some promises are enforceable by formality, and some remedies only apply in specific situations. Question 41. A company's managing director, without specific board approval but within the ordinary scope of her role, entered into a 10-year exclusive distribution agreement. The board later tries to repudiate the agreement as ultra-vires the director's authority. The other party had no knowledge of any internal restrictions. Which authority will most likely bind the company? A. Implied actual authority arising from the managing director's position to enter into ordinary commercial contracts. B. Ostensible authority because the director's act was outside implied authority. C. Authority by ratification if the board later accepts some benefits. D. The transaction is void because it exceeded express limits. The correct answer is A. Let's focus on what a managing director is normally empowered to do. A managing director usually has implied actual authority to make ordinary commercial contracts for the company. Since the distribution agreement falls within the normal scope of the business, specific board approval is not always needed for the company to be bound. The other party also had no notice of any internal restriction, which makes the company's attempt to avoid the agreement even weaker. Option B is not the strongest answer because the facts say the act was within the ordinary scope of the role, so implied actual authority is enough. Option C is not correct because ratification is only needed where authority was lacking at the time. Option D is not correct because internal limits do not automatically make the transaction void against an innocent outside party. The key idea is that a managing director can bind the company through authority that comes naturally with the office. Question 42. Wholesaler Rose bought goods from a manufacturer on terms that title would not pass until full payment. Before paying, Rose sold the goods to a retailer who bought in good faith and without notice of the retention clause. The manufacturer now demands the goods from the retailer. Which exception to the Nemo-DAT rule is likely to protect the retailer? A. The exception of a buyer in possession who sells to an innocent purchaser in the ordinary course of business. B. The authority of Rose as an agent of the manufacturer. C. The rule that retention of title clauses are void against all third parties. D. The equitable doctrine of attornment. The correct answer is A. Let's focus on how title can still pass despite the original restriction. The Nemo-DAT rule normally means a person cannot transfer a better title than they have. However, a buyer in possession can pass good title to an innocent purchaser if the resale is made in the ordinary course of business. Rose had possession with the manufacturer's consent, and the retailer bought in good faith without notice of the title restriction, so this exception is likely to protect the retailer. Option B is not correct because Rose was buying and reselling goods, not acting as the manufacturer's agent. Option C is not correct because retention of title clauses are not automatically void against everyone. Option D is not correct because attornment is not the relevant sale of goods exception here. The key point is that good faith buyers can sometimes be protected even where the seller's title was limited. Question 43. Anna signs a contract to buy a restaurant. The contract states, this sale is subject to Anna obtaining a bank loan of $500,000 by March 30. Anna makes genuine efforts but fails to obtain the loan. The seller demands performance or damages. What is the legal position? A. Anna is in breach and must pay damages for non-performance. B. The contract is automatically terminated and the deposit forfeited. C. The clause is void for uncertainty. D. The contract contained a condition precedent. Since the condition was not fulfilled, the contract is not binding and neither party is in breach. The correct answer is D. Let's focus on what subject to finance does. A finance clause usually operates as a condition precedent, meaning the contract depends on the loan being obtained first. Anna made genuine efforts, but the loan was not approved by the deadline. Since the condition failed without fault on her part, the duty to complete the purchase did not arise, so she is not in breach. Option A is not correct because Anna's obligation to perform depended on the loan condition being satisfied. Option B is not correct because forfeiture is not automatic just because finance was not obtained. Option C is not correct because a finance condition can be certain enough when the amount and deadline are clear. The key point is simple. When a condition precedent fails without fault, the contract does not become enforceable. Question 44. The rule that a promise to accept a smaller sum in full satisfaction of a larger debt is not binding at common law without fresh consideration originates from A. The rule in Pinnell's case. B. The doctrine of promissory estoppel. C. The rule in Folks v. Beer. D. The doctrine of substantial performance. The correct answer is A. Let's identify the source of the rule. Pinnell's case established the common law principle that paying part of a debt is not good consideration for a promise to release the whole debt. In simple terms, if someone already owes $1,000, paying $500 on the due date does not provide fresh legal value for the creditor's promise to forgive the rest. Folks v. Beer later confirmed the rule, but Pinnell's case is the original source. Option B is not correct because promissory estoppel can sometimes prevent a creditor from going back on a promise, but it is not the source of the common law rule. Option C is not the best answer because it affirmed the principle rather than originating it. Option D is not correct because substantial performance deals with incomplete contractual performance, not part payment of debt. The key idea is this. Part payment needs fresh consideration unless equity steps in through a separate doctrine. Question 45. A supplier contracted to sell 1,000 widgets to a factory. Before delivery, the supplier's warehouse was destroyed by a catastrophic, unforeseen earthquake, making performance impossible. The factory had paid a 20% deposit. What is the legal outcome under frustration? A. The contract is frustrated. The deposit may be recovered, subject to the supplier's ability to retain amounts for expenses incurred. B. The supplier must refund the whole deposit because performance is impossible. C. The factory may sue for damages for non-delivery. D. The contract is void for mutual mistake. The correct answer is A. Let's focus on what frustration does after performance becomes impossible. The earthquake was catastrophic and unforeseen, so the contract is discharged by frustration rather than treated as an ordinary breach. The factory may recover money paid before the frustrating event, but that recovery can be adjusted if the supplier incurred reasonable expenses before the earthquake. This prevents the result from being unfairly one-sided. Option B is not correct because the full deposit is not always automatically refunded. Option C is not correct because frustration excuses non-performance, so damages for breach are usually not available. Option D is not correct because the subject matter existed when the contract was made. It was destroyed later, so this is frustration, not mutual mistake. The key point is that frustration ends the contract, and the court can adjust prepaid money fairly. Question 46. Dr. Ellis, a director of MedTech Corporation, learns of a new business opportunity that is directly in MedTech's line of business. Without disclosing it to the board, she takes the opportunity for her own benefit and makes a substantial profit. What is the likely outcome? A. Dr. Ellis may keep the profit because she acted in her personal capacity. B. She is liable only if MedTech was already actively pursuing that specific opportunity. C. Dr. Ellis must account to the company for the profit, as the opportunity constitutes a corporate opportunity usurped in breach of fiduciary duty. D. MedTech may ratify the action, removing any liability. The correct answer is C. Let's focus on the corporate opportunity rule. A director must not secretly take a business opportunity that belongs within the company's area of interest. Dr. Ellis found the opportunity through her position and used it for personal gain without disclosure or consent. That breaches fiduciary duty, so she must account to MedTech Corporation for the profit she made. Option A is not correct because acting in a personal capacity does not excuse misuse of a corporate opportunity. Option B is not correct because the duty can apply even if the company had not yet formally pursued the exact opportunity. Option D is not the best answer because ratification may be possible only with proper disclosure and approval, but the immediate legal outcome is accountability for the profit. The key point is simple. Directors cannot secretly turn company opportunities into personal profits. Question 47. Lara sold a consignment of antique furniture to Max on terms that property would pass only upon payment. Before paying or collecting the goods, the furniture was stolen from Lara's warehouse. In the absence of any agreement to the contrary, who bears the loss? A. Max, because the contract was for specific goods and the risk had passed. B. Lara, because property had not yet passed to Max and risk prima facie follows title. C. The loss is shared equally between the parties. D. The carrier who was scheduled to transport the goods. The correct answer is B. Let's focus on the link between ownership and risk. In a sale of goods contract, risk usually follows property unless the parties agree otherwise. Here, the contract clearly says property would pass only when Max paid. Since Max had not paid and had not collected the furniture, ownership had not moved to him, so Lara still carried the risk when the goods were stolen. Option A is not correct because goods being specific does not override the express condition about when property passes. Option C is not correct because the law does not automatically split the loss equally. Option D is not correct because the carrier had not taken possession of the goods. The key point is simple. When ownership has not passed, risk usually has not passed either. Question 48. A director of a public company approved a contract between the company and a business owned by the director's spouse at prices significantly above the market rate. The director did not disclose the conflict of interest. The company now wishes to set aside the transaction. What remedy is available? A. The transaction is void ab initio and the director is criminally liable. B. The company can only claim damages for the price difference. C. The transaction is voidable at the company's option, and the director must account for any secret profit. D. The transaction stands, but the director must resign. The correct answer is C. Let's focus on the conflict of interest. A director must disclose personal interests that may conflict with the company's interests. The director approved a deal involving a spouse's business and did not disclose the connection. Because the transaction was conflicted and undisclosed, the company may choose to set it aside, and the director may have to account for any secret profit made from the breach. Option A is not correct, because the transaction is usually voidable, not automatically void from the beginning. Option B is too narrow, because the company may have remedies beyond damages, including avoiding the transaction and recovering profits. Option D is not correct, because resignation does not cure the undisclosed conflict or remove liability. The key point is simple. Undisclosed conflicts can make a transaction voidable and force the director to give up secret gains. Question 49, which of the following is an essential element for the formation of a valid contract? A. The agreement must be made in writing. B. The parties must be of the same age. C. Consideration must be of equal value. D. There must be an intention to create legal relations. The correct answer is D. Let's focus on what makes an agreement legally binding. A valid contract needs more than a promise or casual arrangement. The parties must intend their agreement to have legal effect, meaning the law can enforce it if one side fails to perform. Without that intention, the arrangement may be only social, moral, or informal, not a binding contract. Option A is not correct because many contracts can be oral unless the law requires writing for that type of agreement. Option B is not correct because the parties do not need to be the same age, although they must have legal capacity. Option C is not correct because consideration must have legal value, but it does not have to be equal in economic value. The key point is simple. A contract needs an intention to create legal obligations. Question 50. A chemical manufacturer delivered a batch of chemicals to a laboratory. The delivery note stated liability for any defect in the goods is limited to the purchase price. A latent defect clause. A latent defect caused an explosion, resulting in $2 million in damage. The laboratory had no real opportunity to reject the clause. Can the manufacturer rely on the limitation clause? A. The clause may be incorporated by notice, but a court could strike it down as unreasonable under unfair contract terms legislation. B. The clause is automatically void because it was not signed. C. The clause is fully enforceable because the laboratory accepted delivery. D. The clause is void because a limitation of liability for property damage is always unlawful. The correct answer is A. Let's focus on incorporation and fairness together. A limitation clause can sometimes become part of the contract through proper notice, even without a signature. However, that does not make it automatically enforceable. Since the clause tries to limit liability for a major explosion to only the purchase price, and the laboratory had no real chance to reject it, a court may find the clause unreasonable under unfair contract terms rules. Option B is not correct because unsigned clauses can still be incorporated by notice in some cases. Option C is not correct because accepting delivery does not automatically make every limitation clause fair or enforceable. Option D is not correct because limiting liability for property damage is not always unlawful, but it must pass the required fairness or reasonableness test. The key point is simple. A limitation clause may be included in the contract, but it still has to survive legal control for fairness. Question 51. A courier driver, while on delivery, deviated from his route to visit a friend. During this personal detour, he negligently caused a traffic accident. Is the courier company vicariously liable? A. Yes, because the employer always bears the risk of an employee's negligence. B. Yes, under the doctrine of non-delegable duty. C. No, because the employee was on a frolic of his own and not acting in the course of employment. D. No, because the employer had no formal employment contract. The correct answer is C. Let's focus on whether the driver was still doing the employer's work. Vicarious liability applies when the employee's wrongful act is closely connected to their employment. Here, the driver left the delivery route for a personal visit, so the accident happened during a personal detour rather than while carrying out the courier company's business. That breaks the employment connection needed for liability. Option A is not correct because employers are not responsible for every negligent act an employee commits. Option B is not correct because this is about vicarious liability, not a non-delegable duty. Option D is not correct because the key issue is the course of employment, not merely whether the contract was formal. The key point is simple. Once an employee goes on a personal frolic, employer liability may end. Question 52. Peter, a sales agent, was expressly authorized to accept orders up to $10,000. A long-standing customer, unaware of the limit, placed an order for $25,000 with Peter, who accepted it. The principal refused to supply the goods. Can the customer enforce the order? A, no, because Peter acted outside his express authority. B, yes, because the customer had prior dealings and could assume authority. C, yes, but only if the principal had ratified similar orders before. D, yes, under the doctrine of apparent authority, as the customer was led to believe Peter had authority to bind the principal. The correct answer is D. Let's focus on what the customer was reasonably led to believe. Apparent authority arises when the principal represents that an agent has authority, and a third party relies on that appearance without knowing about any internal limit. Peter may have exceeded his express limit, but the customer was unaware of it and dealt with him as a sales agent able to accept orders. That can bind the principal even though Peter went beyond his private authority. Option A is not correct because an internal restriction does not always defeat an innocent customer's reliance. Option B is incomplete because prior dealings may support reliance, but the controlling principle is apparent authority. Option C is not correct because ratification is not required, where apparent authority already binds the principal. The key point is simple. A principal can be bound by the authority an agent appears to have. Question 53. Alice hired a builder to construct a house extension. The contract specified that only top-grade materials would be used. The builder used standard-grade materials that met building codes but were clearly not top-grade, significantly reducing the extension's expected lifespan. Alice terminated the contract and hired another builder. Was she entitled to terminate? A. No, because the builder substantially performed the work. B. Yes, because the express term as to material quality was a condition, and using inferior materials amounted to a breach of condition entitling termination. C. Yes, but only if she first gave the builder a chance to remedy the defect. D. No, because building codes were satisfied, which is a complete defense. The correct answer is B. Let's focus on the importance of the materials term. The contract required top-grade materials, so the builder had to meet that agreed standard, not just the minimum building code. Using lower-grade materials affected the quality and lifespan of the extension, making the breach serious enough to go to the root of the contract. That gives Alice the right to terminate and claim damages. Option A is not correct because substantial performance does not excuse breach of an important quality condition. Option C is not correct because a breach of condition can justify termination without first allowing a cure. Option D is not correct because meeting building codes does not override a higher standard promised in the contract. The key point is simple. When a condition sets a higher quality standard, minimum compliance is not enough. Question 54. The phrase caveat emptor translates to A. Let the buyer beware. B. Let the seller beware. C. Let the contract speak for itself. D. Let the law be the guide. The correct answer is A. Let's keep the Latin phrase easy to remember. Caveat emptor means the buyer must take care before buying. It places the risk on the buyer to inspect the goods and make a careful decision, unless there is a warranty, fraud, misrepresentation, or a legal protection that shifts responsibility to the seller. Option B is not correct because that would place the warning on the seller instead. Option C is not correct because it refers more to interpreting the contract, not buyer risk. Option D is not correct because it is not the translation of the phrase. The key idea is simple. Caveat emptor means buyers should beware before they buy. Question 55. A software developer, Tom, contracted to create a custom database for a law firm. The contract stated, time for delivery is not of the essence. Tom delivered 4 months late, causing some inefficiency but no fundamental loss of business. The law firm wishes to terminate the contract and claim damages for delay. Can it terminate? Yes, any delay justifies termination. B, no, because the firm waived the right to terminate by not complaining earlier. C, no, because where time is not of the essence, a mere delay does not give a right to terminate unless the breach goes to the root of the contract and deprives the firm of substantially the whole benefit. D, yes, because the breach is a breach of warranty. The correct answer is C. Let's focus on how serious the delay must be. Where time is not of the essence, late performance does not automatically give the innocent party a right to terminate. The delay must be so serious that it defeats the main purpose of the contract or deprives the other party of substantially the whole benefit. Here, the late delivery caused inefficiency, but not a fundamental loss of business, so termination is unlikely, though damages for delay may still be available. Option A is not correct because not every delay justifies ending the contract. Option B is not the best answer because the key issue is the seriousness of the breach, not waiver. Option D is not correct because a breach of warranty usually gives damages, not a right to terminate. The key point is simple. When time is not essential, delay must be seriously damaging before termination is allowed. Question 56. Mark and Lisa orally agreed to run a cafe together, sharing profits, losses, and day-to-day management. They never registered a formal partnership or signed a written agreement. Are they partners at law? A. Yes, because a partnership can be formed by oral agreement and by the conduct of sharing profits and management, regardless of registration. B. No, because a partnership must be registered to have legal effect. C. Yes, but only if they file a partnership deed within 30 days. D. No, because a written agreement is essential to prove mutual consent. The correct answer is A. Let's focus on the substance of the relationship. A partnership can arise without a written document if the parties agree to carry on business together with a view to profit. Mark and Lisa shared profits, losses, and management, which strongly shows a partnership relationship in practice. Registration or a formal deed may help with an organization, but it is not what creates the partnership by itself. Option B is not correct because registration is required for a partnership to exist. Option C is not correct because there is no automatic 30-day filing requirement for partnership formation in this rule. Option D is not correct because mutual consent can be shown through oral agreement and conduct. The key point is simple. Partnership depends on what the parties actually do, not just paperwork. Question 57. A bank granted a company an overdraft facility with the personal guarantee of the managing director, Ms. Chen. Ms. Chen is now resisting enforcement of the guarantee, arguing she felt pressured, and the bank did not recommend she seek independent legal advice. Which doctrine is she most likely to rely on? A. Duress to the person. B. Unconscionable bargain. C. Undue influence, particularly where a relationship of trust and confidence exists and the transaction calls for an explanation. D. Non est factum. The correct answer is C. Let's focus on why the guarantee may be challenged. Undue influence can arise where a person is pressured into a transaction, especially one that benefits someone else and calls for proper explanation. A personal guarantee for company debt can raise concern if the guarantor did not receive independent advice and may not have fully understood the risk. If the bank was put on inquiry and failed to take reasonable steps, the guarantee may be voidable. Option A is not correct because duress to the person involves threats of physical harm or similar direct pressure. Option B is not the strongest answer because the issue is pressure and lack of independent advice, not merely an unfair bargain. Option D is not correct because non est factum applies where a signer fundamentally misunderstands the nature of the document, not simply where they regret a guarantee. The key point is simple. Guarantees signed under pressure may be challenged through undue influence. Question 58. A retailer ordered 500 units of specialty goods from a supplier on 30 days credit, title to pass upon full payment. The contract also stated that proceeds from any resale must be kept in a separate identifiable account for the supplier. The retailer received the goods, sold 300 units to customers, and then defaulted on payment. The supplier claims the unsold 200 units and the proceeds of the 300 sold units. What is the likely outcome regarding the sold units? A. The supplier cannot claim the proceeds because title had not passed. B. The supplier's retention of title clause is void against third-party customers. C. The supplier may reclaim the sold goods directly from the customers. D. The supplier can claim the identifiable proceeds if the contract created a fiduciary duty to hold them on trust. Otherwise, the claim is limited to the unsold goods. The correct answer is D. Let's focus on what happens after resale. A retention of title clause usually helps the supplier recover goods still in the retailer's possession because ownership has not passed. However, once goods are sold to customers in the ordinary course of business, the supplier usually cannot simply take them back from those customers. If the contract clearly required resale proceeds to be kept separately for the supplier, it may create a trust-style obligation, allowing the supplier to claim identifiable proceeds. Option A is not correct because a properly drafted proceeds clause may allow the supplier to trace into resale money. Option B is not correct because the clause is not automatically void, though it may not defeat innocent customer rights. Option C is not correct because customers who bought in good faith are usually protected. The key point is simple. Retention of title protects unsold goods, but proceeds require clear trust wording and identifiable funds. Question 59. Which statement correctly describes the difference between a condition and a warranty in contract law? A. Breach of a warranty always entitles the innocent party to terminate the contract. B. A condition is a minor term. A warranty is a fundamental term. C. Breach of a condition entitles the innocent party to terminate the contract and claim damages. D. The classification depends solely on the severity of the breach. The correct answer is C. Let's keep the distinction sharp. A condition is an important term that goes to the root of the contract. If it is breached, the innocent party can terminate the contract and also claim damages. A warranty is a lesser term, so breach of it normally gives only a right to damages, not termination. Option A is not correct because breach of a warranty does not usually allow termination. Option B reverses the rule because the condition is the fundamental term, not the warranty. Option D is not correct because classification depends on the nature and importance of the term, not only on how serious the breach later appears. The key point is simple. Breach of a condition can end the contract, but breach of a warranty usually only leads to damages. Question 60. A courier driver, while delivering a parcel, briefly stopped his vehicle to assist an injured pedestrian, leaving the engine running. The vehicle was stolen and caused an accident. The courier company is sued for negligence. Is the company vicariously liable? A. Yes, because the driver was still acting in the course of employment, and a momentary deviation from the prescribed route does not constitute a frolic. B. No, because the driver's act of leaving the vehicle was a criminal act. C. No, because the driver was on a frolic of his own. D. Yes, under the principle of a non-delegable duty of care. The correct answer is A. Let's focus on whether the driver had stepped outside his job. The driver was still in the middle of making deliveries, and the stop was brief rather than a personal trip unrelated to work. Even though leaving the engine running may have been careless, the act happened during the course of employment. A small deviation does not usually break the connection between the employee's work and the employer's liability. Option B is not correct because the driver's negligence is the issue, not a criminal act by him. Option C is not correct because helping briefly during delivery is not the same as going on a personal frolic. Option D is not the best answer because the main issue is vicarious liability, not a non-delegable duty. The key point is simple. A brief work-related deviation can still keep the employer liable.